All right, we're going to jump in and get started in a second. I just need to get everything set up. Can you, anybody that's out there, do me a favor and on the right side of your control panel, just type a message at the bottom there to me and tell me if you can hear my voice and see the PowerPoint presentation so I can make sure that the visuals are good before we jump in and start. Anybody out there, just I need to make sure somebody type into the, I think it's your message. Okay. All right. Looks like we're good to go. So I want to welcome you all to the Micklin Law Group's monthly webinar series. Tonight's webinar is Probate in New Jersey, a post-Prince review on why you need an estate plan. And just in case for those of you that might not know, I am not talking about Prince Charles or the Prince of Wales. I'm talking about the rock star Prince who died allegedly of an overdose earlier, I guess this year, 2016. He had over $400 million in assets and no will. And they paid, I believe it was over $100 million, if not much more, in estate taxes. It's insane. And obviously, a person like that would have had legal representation and advice, and the malpractice there is unbelievable. So it seemed like a good time to do a webinar like this again for everybody. So let's jump right into it. Excuse me, I had a little bit of a sore throat from traveling. Let me give you a little expectation for today's webinar. It is scheduled for 60 minutes. I never know how long a presentation will go. I just talk until I get the information I think you need to know. I do try to end early so that you're not here longer than anticipated, but I give as much time at the end for questions that you may have. I make sure to answer all questions that arise. I usually recommend that you write them in the place where you noted that you can hear in your control panel so that you don't forget it as we're going through, and then I'll get to it at the end. But I don't stop during the webinar to actually address it. You should also know this is a one-way communication, so hopefully you can see the presentation and hear my voice, but I wouldn't be able to hear you, so you can't actually ask me questions other than through typing them. I have uploaded the PowerPoint presentation, so if you're interested in getting a copy of it, I think you should be able to print it out from there. I will also post a version of the recording. This is being recorded onto my website, micklinlawgroup.com, as well as my YouTube page, which I think you can find by searching my name, Brad Micklin, M-I-C-K-L-I-N, and you can use the PowerPoint to accompany it. The reason I do these webinars, I started doing these a few years ago, is I realized as I met with clients that it was impossible to give somebody all the information that they need to know about any given case, whether it's in an initial consultation or even throughout my entire representation of somebody, which can often be years at a time. There's just so much information, it's impossible to convey it to a client and give them everything they need. So I started putting together these monthly webinars as well as some ebooks and videos on my website to create sort of a library of information so that both clients and interested clients have a base to go to obtain the information without having to come to me and incur legal fees to get it. Find it helps people move along a lot more easily in their cases. Also helps them know better what they do and don't know, so that when they do ask questions, they're more intelligent, more well thought out questions. It's important to note this webinar is being recorded January of 2016. That's significant because as with most laws, but especially in estate planning laws, there are going to be changes in the next coming years. Some of them we will touch on tonight, but in general, laws can change quite often. So if you're watching this significantly later than 2016, did I say January 2016? I'm sorry, it was December 2016. If this is significantly later, 2017, 18, or after, you're going to have to update to see what changes in the laws may have occurred. And that's really the same with all my webinars. I just started including these dates in them now when I realized that was an issue. So let's move on and give you a little bit about me in case you haven't met or aren't working with me. This is me. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I've been practicing law since 96, I think, 96, 97. I started as a judicial law clerk for Eugene Austin in Bergen County, Special Civil Part. I then went and did complex commercial litigation with Kessler and Associates for a number of years, and then I opened my firm in 2001 as a general practice attorney, which means I did a little bit of everything by myself. I quickly learned you can't be great at everything, so I concentrated my practice into divorce, family law, and estate planning early in 2000s-ish, maybe 2002. And since then, I and my firm concentrate solely in those areas. I tend to handle the more high complex, high net worth cases, higher conflict cases, and the rest of my associates handle the lesser conflicts and smaller issues. I've been fortunate to receive a number of awards over the years. This is actually not updated. I have a number of these for 2016, but I list them here not to sort of toot my own horn, but for those that aren't working with me and that may not have worked with me or may not even have met me, and those who listen to this in the future, it's good to know that you can trust that I have some sense of what I'm talking about and that I really have my client's best interest at heart when I speak on these issues. Because most of my webinars really come from more of a position of what does a client need to know in practice than really what is necessarily the law. So without further ado, let's talk real quick what we're going to talk about today. We're going to talk about wills, which are just the written documents that discuss how you want to dispose of your property when you pass. We're going to talk about trusts, which are vehicles. I always make an analogy to like a corporation. It's a legal entity that exists to hold assets and to shelter assets and give tax advantages, simply put. We're going to talk about other estate planning devices like powers of attorney and healthcare directives, and a little bit about non-probate assets, which means assets do not pass through your estate, as opposed to what is called probate assets, which do pass through your estate, which will be largely what we're talking about. So let's first talk about wills. So what is a will? It's a formal document that describes how you want to distribute your assets and valuables. It should be typed or printed, and I say printed because you want to make it legible, and it's got to be signed by the person making the will. As a quick aside, the law has been relaxed a little bit. It used to be very rigid in all areas of estate planning, but it used to be very rigid in the requirements of a valid will. So if there was even a slight variation, your will did not pass. They've started to water that down, understanding the changes in technology as well as the changes of more informal methods of creating documents and word processing, that they now have weakened the requirement. Still needs to be signed, but it could be like a scribble if somebody's in the hospital. It can also be certain portions now that, as long as the portions are relevant and signed, that has been upheld, where 10, 20 years ago, if the slightest imperfection was in the execution or the formality of a document, it failed. So moving on to additional requirements, it must be signed by 2 witnesses. You must present the witness to the execution, and each person must be witness the other signing the document. The reason is just so that later, and what we talk about here, in certain circumstances, the witnesses need to appear in the surrogate's court to attest to the signing of the will. Now, I recommend that you have your will notarized in what's called a self-proving provision, which is largely a standard provision in most wills now. That allows the witnesses to self-prove and through the notary, so that when you offer the will into probate, you do not need the witnesses to now appear in court. It can be very inconvenient. A lot of times you don't know who the witnesses are. When you get somebody's will, it could be 10, 20 years later. People move. You might not know where they live. So it's a common practice now that all wills, or most wills, are usually self-proving. Any lawyer who does a will, it's likely to do it self-proving. If you're unfortunate enough to use those online services and prepaid services, they're usually going to have self-proving provisions also. It just makes the most sense, because you don't want to have to start hunting down witnesses to make sure that the will is actually valid. So who can make a will? Several requirements to make a valid will. First, you must be 18 years or older, and that means that you have to be able to be the lawful age of contracting. And in New Jersey, that's 18. And you have to be of sound mind. So sound mind, it's hard to describe what sound mind means. It's a very low threshold of capacity. It's not to the point of a guardianship issue, but your capacity doesn't need to be much greater than a basic level of understanding. You need to have what's called testamentary capacity to be considered sound mind, which means you need to know the nature of the acts that you're making the will, the natural objects of your bounty, which is who gets your property, the nature and extent of the property, and you have to understand what the will is actually doing, which is the disposition of your assets. So again, that's a very low threshold, and most people will satisfy it. Even those that may be on the borderline of losing their capacity, still going to be considered of sound mind. That's why it doesn't say of sound capacity. It's very finite different, but it's a very distinct one. Moving on into New Jersey specific areas, I mentioned when I did the intro, there are significant changes, and there will be in times to come. Right now, as of, well, this says November, but it's December, estate taxes in New Jersey are issued against the states with a value of $675,000 or more. It's going to change in 2017 that there will not be a New Jersey estate tax if your estate is under $2 million. And then going forward, and I may be premature because the slide may cover this, in 2018, the New Jersey estate tax will be repealed entirely, so there will be no New Jersey estate tax on your estate. Now, don't be confused with federal estate tax, and don't be confused with inheritance taxes, which we'll talk about in a second. This is solely New Jersey estate tax. But it's significant because the $675,000 threshold is a relatively new phenomenon in New Jersey's history, and not more than a handful of years ago. Simply put, there was no estate tax in New Jersey unless you had a sizable estate. That was changed a handful of years ago for a purpose of generating revenue, and now it's being phased back out. So those that have done wills in the recent past, those that have done some now or will in the future, should do so, because it's important to have it done now, but you're going to need to revisit it in the next year or two, which will cover reasons why you should anyway. Generally, I think everybody should revise and review their will every couple years. Another change, as I was saying, in 18, it's going to be repealed. There still will be federal estate tax, so I was saying don't confuse the two. Federal applies to estates over $5.4 million. It's actually more like 10 if you're married. There's a carryover provision. Most of the people that are probably going to be hearing this webinar are not going to have estates over $5 or $10 million, so I'm not going to go deep into that. There's also going to be a change when they repeal and lose the revenue from the estate tax, New Jersey that is. There's going to be an increase in gross income tax exclusion for pension and retirement income. So I think that's where they're going to look to pick up the lost revenue. Here are the numbers, just real quick. Get my fancy pen out here. I'm not going to go into it in detail. These are the limits that are going to be affected by it, sort of outside the scope of an estate planning webinar, but I think it's important when we're talking about changes in the tax laws to know that these are going to be also taxes. Pension and retirements are very significant portions of people's estates, which brings me to the point I was going to say a moment ago. Let me just step back. The reason why the 675 limit is so important is because it includes all assets to an estate, even probate and non-probate, which we'll go into later in the presentation. 675 is not a great deal of money, even if it sounds to some like it is, because it counts life insurance policies and pensions. And those can often be, in the $1 million ranges. You can have a $5 million term policy that you're paying a very small amount for, and you're going to have a significant New Jersey estate tax without proper planning. So I forgot to mention that when we were on that, so I just want to step back. Now, we already talked about this. Let's move on to here. New Jersey inheritance tax remains intact. That's what I was saying a moment ago. Don't confuse. Federal estate tax is one. New Jersey estate tax is another. And inheritance tax is a third. An inheritance tax is a significant tax to be considered when planning, and a lot of people don't. It's imposed on transfers of certain assets to benefits who are not the spouse, parents, grandchildren, or children. Beneficiaries are sorted into different classes. And their classes named just alphabetically, A, B, C, and D. The rates, it's a progressive rate, so it's anywhere from 11 to 16%. And it's a significant issue when you're planning your estate. I'll often, and I'll make it simple, anybody outside of these classes will pay the inheritance tax. And that's significant. So if you're leaving to a nephew or to a friend or to an intimate partner, you need to consider the potential inheritance taxes because it will often disrupt your intended disposition. Meaning if you have a house or a condo that you're leaving to your dear friend or to your nephew, and there's an inheritance tax that person will have to pay for the inheritance, in many cases they need to sell that property in order to pay the inheritance tax. So what you intended to convey to them gets liquidated to pay your taxes. There are a lot of vehicles to sort of arrest that issue. I don't know if they're part of this presentation. The most common, the easiest, I think, is to use life insurance. Life insurance, you usually pick up a good amount of coverage for a relatively minute price in comparison to the benefit to pick up what may be the inheritance tax that a beneficiary may receive. Now, a couple of things about New Jersey, the final requirements about your will. The witnesses can be a beneficiary. Just go back to my pen here. It is permitted, but I don't recommend it. There's a lot of reasons in some cases that suggest if you have an interest in the will, you shouldn't be the witness to it. Sort of just a conflict. And if you are one of those that needs to come and attest to the validity of the will, if it's not self-proving, for instance, then there's going to be an issue. There's a conflict, so the credibility gets diminished, and it raises issues that you don't need. When it comes to something insignificant like having a witness a signature, it's best to sort of dot your I's and cross your T's. Do whatever you can to avoid potential problems for your heirs in the future, which is the whole reason you're going to do estate planning in the first place. Second is choose somebody in New Jersey to act as your personal representative. In your will, you're going to name an executor who is a person that will handle your will and your estate once you are deceased. You may name a trustee to handle future monies of people. You may name a custodian or a guardian for children. Most of these people should be in New Jersey just because the nature of the responsibilities they will undertake inside of your will often be very difficult to accomplish if they're out of the state. If you are going to pick somebody out of state, at least talk to them, if you don't mind, and explain this to them and make sure that they are going to be able and willing to do so. Or in the alternative, name 2 or 3 alternates in case they're not able to, which is something you really want to do in all estate planning anyway. Anytime you name any type of fiduciary, whether it be an executor, a trustee, a guardian, you want to name 2 or 3 alternates because who knows what's going to happen in time, who knows what's going to happen with their lives, whether they are able or willing to do it when the time comes. You want to have those questions answered so that your family isn't burdened with the option of trying to discover that answer by going to court. So why should you have a will? First, it's to decide how your estate is distributed. Like I was saying about the inheritance tax issue, for instance, you want to ensure that those that you really want to receive your property will in fact receive it. It avoids the probate process, which is the formal court process, or prolonged, you don't avoid probate. You avoid prolonged probate, meaning all wills have to be probated in New Jersey. But if you don't have a will, it creates significant difficulties in probating your estate. Courts have to determine who is going to be the one that serves as your executor. There could be many family members that fight over that. There could be issues about guardianship if you have children. And then there's also contest issues. So by not having a will, and then also how your property is distributed. Part of the probate property will be to determine under what's called the intestate statute who gets your property when you fail to designate it. Can minimize estate taxes. Usually having a will should account or plan for the estate tax issues. That's not a definite, of course, that's only with proper planning. Allows you to choose your fiduciaries, which are the people we were just talking about, your executors, your trustees, your guardians. If you don't have a will, all of these fiduciaries need to be appointed by the court in some process, which is often very lengthy, costly, and extremely difficult when you're already bearing the loss of somebody who's usually probably very dear to you. And then lastly, you can disinherit people. There may be people in your life that you want to ensure don't receive your assets. You may be estranged from a parent, and if you die without a will, that parent will, in fact, inherit your property. And like I said, the law for estates very rigid. So even in most cases where it's clear the person would not have wanted somebody to inherit, they will often do so. I had a case years ago where a client came to me and her nephew had passed. He was a fireman. He had a condo and a pension, had no relationship with his father because his father was just an ass. And he died without a will, and his father was going to inherit all of his property. We took the issue to court and urged the court to set aside the intestate statute based on the fact that my client, or the decedent, my client was actually the estate, but the decedent was dyslexic. And I argued he was not capable of understanding what was needed or being able to actually execute and develop one, having this limitation. The court actually accepted the argument, set it aside for a hearing. It never actually went through. The issue was resolved between the parties, but it was an aberration, to be honest with you. I didn't expect the court to rule that way. I was happy they did, of course, but I never expect the court to go against anything that's so rigid like those laws. So if you have situations like a sibling that you want to make sure doesn't receive a parent, again, you need to provide for it in your will. Other issues, it avoids and minimizes what are some of the most difficult, costly actions you'll have. Legal challenges, will contest, and disputes. I do a significant amount of will contests, and I can tell you they're ugly. All of them are, no matter what side of the case you're on. It's something about money and family that is just a very bad mix. More often than not, it's not somebody trying to sneak something in or steal something away, but people create or obtain some kind of feeling of entitlement. A common situation is, brother or sister move in to take care of mom when she's ill, and they lives there for a year and spends mom money on mom's care and themselves, and they feel entitled to take reimbursement for like their car payment, and because they wanted to go away, and then they feel like mom would have wanted them to have the house because she may have said so because she was alone and they were the only one taking care of her. So they have the house transferred. All of this has to be undone, whether there's a will or not. And that's what the will contest is. Will contest is usually a very lengthy, costly piece of litigation for circumstances very similar often to the ones I just described. Next, peace of mind. Peace of mind of knowing that you have avoided all of these issues, as well as the issues we've already talked about, like your inheritance tax, your estate tax, the naming of guardianships and executors. As I mentioned, it controls the particulars of the distribution, so you can ensure that who gets the property is intended to those. Then there's also these two issues here. They're similar but different. Spendthrift issues. These are when you have issues concerning the people that receive your property who may have money problems, they may have spending problems, they could have drug problems for all you know. There could be reasons why, although you want them to have your assets, you don't want them to have the freedom to spend it however they want. So you can put in what's called a spendthrift provision that prevents that. You may also have heirs, family members, children that you're concerned of divorces in the future. A divorce is a creditor, so it's a spendthrift issue. And then protection from Medicaid. As all of us age, Medicaid's becoming a bigger issue. Our generations are living longer, but we're not earning more. So Medicaid's going to be an issue. You want to properly plan for Medicaid, not only for yourself, which we'll talk about later when we talk about trusts, but there may be people that you're leaving money to who in their future might want to qualify for Medicaid and may be prevented because they have an inheritance and a chunk of money or an asset that they inherited from you. So you may need to plan for others that are going to live beyond you to make sure that their life is still comfortable also. And of course, like I said, around spendthrift issues, it's protection from other creditors. We'll get more into that when we talk about the trusts. So as I said in the beginning about the change in the laws when you need to update your wills, now's a good time to talk about when you should. And I mean, I think you should every year. But I put in a few years, every few years, because I'm lucky if people just do it even that much, because I'm just happy when people do their will in the first place. But the laws change. As I said, I mean, New Jersey's state tax is going to change. Significant changes in life, marriage, separation or divorce. Um, Marriage changes it because it's just a change not only in your marital situation. You may not be crazy about the in-law. There might be pre or post-nuptial agreements. With the separation or divorce, there's one interesting point. Um, the will is not automatically invalidated or invalid upon filing a divorce, but once the divorce is granted, I believe it is revoked by operation of law, which means it no longer exists. The intention is somebody gets divorced and dies the next day, they probably would not want their spouse to inherit their property, so it's considered as if their will is revoked. But during the divorce, it may not be. So you may want to review it. If you're getting divorced, you may want to revoke it then, even if you're not going to draft a new one. Other life issues, sort of triggering events. In a sense, it's almost any significant life change. Birth or adoption, acquiring or losing a significant asset, relocation, and any kind of life change. And that's going to vary by person, because what is significant to one person may not be significant to another. But changing jobs, marriage, death, divorce, all the pleasant topics that you want to talk about. Good times to review, and just for the passage of time. Sometimes your assets change, the nature of your holdings change, the economy changes, things that don't most people don't consider changes in the economy as a reason to review your will, but it often is, because it changes in the taxes as well as the value of your assets. So now, if you have a will, let's talk a little bit about. I'm sorry, got some more trigger events. Disability or receipt of government benefits. Again, just a change in your incomes and assets. Changes in the life of an heir. So if any change that would be a change for you to review your will, birth, death, marriage, divorce, is also the same reason why an heir would do. With one extra caveat here, which we'll also get into later with trust, is the receipt of governmental benefits. We'll talk a lot about the importance of this with trust planning, but you really need to contemplate the people that may be receiving your assets and what their future may hold, then their children, their lives, their families, because you want to make sure that the receipt of your estate or your inheritance is a blessing, and you want to make sure that there's no negative consequence to that. Now, how does the process work? You have to file to probate the will in a surrogate's court in the county where the decedent resided at the time of his or her death. That can be a complicated issue because some people will have multiple residences. Often an older individual may be visiting with a younger relative for care and may be there for a couple months, but their residence could be in a different state. It can be very complicated. We usually go by a driver's license or real estate, but it's certainly an issue that sometimes complicates it. When you go to the surrogate's court, this is what most of them will require, that you bring the original will. Now, if you don't have the original, which is often the case, there are ways to file certain papers to ask that a copy be admitted. But if you can get the original, it's certainly better. It saves you time and a lot of hassle. The death certificate with a raised seal, again, it's got to be the original. You usually get that from the funeral home. The executor or administrator, which real quick, just these two are the same thing. An executor is a person that handles in the estate of a person who died with a will. An administrator is the person who handles the estate of a person who dies without a will. Same job, different titles. Photo ID, so that they know that you are in fact a person. Probate application, usually you can get that online. Sometimes the surrogate's court will mail to you in a filing fee. I don't remember what the filing fee is. There are a small handful of counties in New Jersey, I believe Morris is one of them, that requires you to physically go, the executor or administrator, physically go and fill out the papers and be appointed administrator or executor. It's very inconvenient. It's not very common, but it pays to call each county, or not each county, but whatever county you're about to probate in, if you're not handling it with a lawyer, or if you are a lawyer who may not be experienced in these areas, call the court and find out, the surrogate's court, to find out what is required so that you don't send a client running into circles again. always keep in mind that the people involved, whether it's estate planning, probate, will contest, are either contemplating a loss or dealing with a loss, a very significant one. So you want to make the process as easy as you possibly can. All right, so let's talk a little bit more about the specifics. We did talk about this minimizing estate taxes. Again, federal, it goes off every time you change it. Federal currently is 5.4. It can be 10, or I guess 11 if you're married. New Jersey is taxed if you're over 675. And the spousal exemption, I'm not going to get into spousal exemptions. I talked a little bit about it with the federal here. And we'll talk about a little bit, not the exemptions, but we'll talk about spousal planning a little later into the webinar. But I'm going to move on because I might be going a little slower than I anticipated. Inheritance taxes, as I said earlier, between 11 and 16%. It's a graduating. It's based on the class of beneficiaries. If you are going to leave beneficiaries and you do have inheritance tax issues and you're comfortable with that, because I'm not saying that's the thing you shouldn't do, but you want to at least find out what class they're in and what their tax rate's going to be. So at least you might be able to plan around the loss or the cost. Like I said earlier, insurance is a good way to do it. Gifting, which we'll talk about briefly also, is a good way to address it. But at least you want to know what it is. You want to have a firm grasp on the consequences of your estate. So turning to what I just mentioned a second ago, gifting. It's a great way to minimize estate taxes. There are certain things you need to know and certain things that you need to watch. Gifts between spouses are tax-free and unlimited. Gifts to everybody else is maxed, I think, at $5 million. Lifetime exemptions. I'm not going to go into a lot about gift taxing issues, but there's often a lot of misconceptions about I think it's like $13,000 annual gifting amount. And people think that if you gift more than that amount per year that there's going to be a tax. It's not. It's simply a reporting requirement. So you can gift up to $5 million without a tax consequence. But you may have a gift filing or a gift tax return filing requirement. So just talk to an accountant or an attorney that does estate planning if you're going to be gifting sizable amounts of money, but don't get caught up in what everybody thinks is a common misconception about it. These are limits I just told you. They must claim the gift. And that goes back to old, just basic common law. That a gift requires, I think it's 3 requirements. It has to be tangible, has to be offered, and it has to be accepted. So if you make a gift, if you tell somebody you're making them a gift, but you don't deliver it, you keep it in your house, it's not a gift, it's not completed. So it wouldn't count. One other thing is I believe there's a 3-year look-back period, whereas if you transfer assets within 3 years of passing, the state can look back over those transfers and count them as part of your taxable estate. Now, the hard thing about that is most of us don't know if we're going to be alive in 3 years. Most of us don't really know if we're going to be alive in 3 days. But it's something to be aware of. Doesn't mean that you shouldn't necessarily do it, but you might want to contemplate the tax, not just the tax consequences, but all the consequences that could result from gifting something now that could be reversed or used as added to part of the taxable estate when you pass. All right, let's move into trusts. Now, trusts, a lot of people have misconceptions about trusts. We're going to talk just briefly about the different types and benefits of them, but people think of trusts as this old, fancy, complicated, sophisticated thing that banks handle. And it's really not. A trust is nothing more than a legal fiction. It's something that the law says is there but doesn't really exist, like a corporation, like McDonald's. McDonald's, if you took away the buildings, McDonald's would still be there. They would exist as a corporation, but it doesn't actually exist. And that's what a trust is. A trust is just something that changed the title of an asset, so your house, instead of being titled to you, be titled in a trust, and you have a separate bank account and you file a separate tax return. So it exists, but it's not in existence. But it's not that sophisticated. I might even be making it worse by trying to make it simple, but it's not like people used to think it is. So let's look at the first kind. The first is a living trust. The purpose of a living trust is to avoid probate, reduce problems with joint owning properties, and creditor protection. Basically, this is a trust that you can set up yourself, you can control, and you can put assets into this. The assets you can also then designate when you die who it goes to, so it will go automatically to them For instance, if you put your house into your trust, into your living trust, and your trust says, my friend gets it when I die, your friend can get a new title the day after you die. If you put it through a will that goes through probate, you may have 6 to 12 months before the title is changed and the estate is completed. So it's a much more quickly disposition of your property and avoids the whole process. Avoiding dangers of jointly owned property, because if you own property, in many cases, the other co-owner will inherit your share of the property because of the way it's titled and because of certain presumptions in the law that we won't go into. It's more of a real estate matter. But a lot of people don't understand that, and they lose the ability to pass their part of the property to other people. And it doesn't have to be real estate. Jointly owned assets can be bank accounts. It can be stock accounts. You might have a stock account with your brother or something, or you put your nephew on it because you need the convenience so that they could bank for you. That will often lose your control over it in estate planning because you don't actually own it. So if you transfer it to a trust, you change the type of ownership. And then creditor-in-law protection, because the trust now owns the property. You are no longer its owner. You control it while you're still here in a living trust, but you don't own it, which is a very important distinction through all the trusts, which is why we'll talk about in a second some of the tax savings that some trusts give you. You can change it or revoke it during a lifetime. So this is one of the main benefits of a living trust as opposed to other ones. It's revocable. We'll talk about different kinds that are not, but revocable allows you to keep control of your property so that if you put your house in, for instance, and you want to sell it or the tax laws change, you can change it. In some cases, I think New Jersey one, you can lose the homestead protection. So again, you do want to talk to your accountant before making these kinds of transfers. And as a caveat, I know I talk a lot about transferring houses because that's what a lot of people do. There is one thing I tell all my clients: if you have a mortgage against your property and you transfer it into a trust, most mortgages, most conventional mortgages will have a clause that states if you transfer title in any way, it's an automatic default that will allow the mortgage company to accelerate all payments due on the mortgage, which means if you transfer the property, they can foreclose on it. Now, in the 25 years or so I've been doing this, I've never seen a bank actually do that because they don't want your property, they want your payments. But you do need to know it is a possibility, and it's a very big risk, so you need to understand it before you do transfer real estate into a trust. So even though I use it as an example, don't think it's the most common thing to do or that it's easy. Tenants by the entirety may lose creditor protection. This goes to what I was saying before. Tenants by the entirety is a type of ownership where the two people co-own what's theoretically considered every molecule of the property, so that you can't divide one person's interest from another. You transfer that into a trust, and that's now not necessarily the same. If one of them has, or one of you has a creditor out there, you may lose what was previously protected. The next kind, more common kind, irrevocable. And that is just as it sounds. It's irrevocable, cannot be revoked, cannot be changed. Significant benefit, creditor protection. It can be used, irrevocable life insurance trust can be used to pay estate taxes and makes your funds immediately available to those that survive to you once the insurance is paid over to it. This is a certain type of trust. Don't be confused by the fact of a trust having to hold an asset when your life insurance may not actually be an asset because you don't actually have any of the benefits yet. The trust will become the owner of the life insurance policy, and we'll talk a little bit about funding it and how to make the payments to it. But none of the assets actually exist in that trust until your death and the premium is, or the death benefits are paid over. But once those are paid over, they are protected from creditors, they are protected from estate taxes, and they're immediately available to your heirs. In case that wasn't clear the way I said it in the first place. One of the main benefits, again, it delays the expense of liquidating other assets, as I said in the beginning. For instance, when you have an inheritance tax issue, you may have bills that need to be paid. You may have one of your heirs getting all of your property, but some of your, you have to pay the mortgage or taxes are due. A lot of freedom and flexibility in an irrevocable life insurance trust, also called an ILIT, I-L-I-T, you see on the end there. The trust will have instructions, usually for the trustee, of how to handle distribution of the policy, the death benefits. The estate should not be the beneficiary. In your life insurance, in your irrevocable life insurance trust, you'll name a beneficiary. It should not be your estate. If it is, if you do make it your estate, then you're going to lose the creditor protection and the tax protection because it just circles back to you. So the whole reason you would set it up is to avoid it going through your estate and going through probate. Now, there are two kinds of ILITs. First is an unfunded. Premiums are not fully paid. You fund the future premiums by giving them to the trust you pay them. You can't pay them directly. It's just an important distinction to keep the protection of the trust itself. Contrary to the funded, you can transfer either the payments to the trust, or you can transfer a fully paid policy or assets that would produce income to pay the premiums. But it's got to be paid directly by the trust. Very important distinction. It's a formality of putting your money into the trust or the trust account, having the trust pay it, but it's a formality that's going to be crucial. I'm sorry, and I hate to use the word formality because people talk about legal formalities, and I would say there's no such thing as a legal formality. It's just simply what the law is. So like I said, you can't directly pay them. The purpose of doing that is to protect the proceeds and save on taxes. I'm not going to belabor these points because I think we've talked about them before. It's just important to remember the basics about how to manage and handle them. Benefits, more control over the distributions than if you owned it purposely or personally. Like other things that we talked about, you can have spendthrift provisions, discretionary distributions, meaning you can have somebody that's a beneficiary of your trust get monies over a period of time instead of getting all of them. For instance, you may be leaving money to a child or a non-relative child or just an immature person. You don't want them to get all the money and go out and buy themselves a very nice car, so you can give them distributions at important stages of their lives. Also, it avoids court if there's a capacity issue. We talked a little bit about guardianships earlier. Life insurance companies won't pay life insurance to an incapacitated beneficiary. There needs to be a guardianship, but they can pay it to an ILIT, an irrevocable life insurance trust, whose beneficiary is incapacitated. Children's trust, I'm not going to spend a lot of time on children's trust. They're not very common. Main benefits, it reduces taxes because children are generally going to be taxed at a lower income rate than the adults. It's not included in the taxable estate because, like every other trust, you're transferring property into the trust, so it's no longer your property. It's now the trust's property. Couple drawbacks or things to be aware of with a trust. If the person or when the person becomes 21, they can demand money from the trust. That may not be what you wanted to do. Most of the time, you're either trying to shield it for your own tax advantages or you're trying to protect the child from him or herself. So giving them a trust vehicle that allows them to demand distributions may not be worth the tax savings that you're getting now. A couple other provisions, I'll give you a second if you want to just jot them down. I'm not going to spend time because I think I am a little bit further behind than I wanted to be. Next trust, also not spend a great deal of time on. If you have questions about these, you certainly talk to me. Charitable remainder trusts. Again, these are usually for larger estates. The main advantage, as with most trusts, of course, you get credit protection. But the main advantage here is the immediate tax deduction. You can put a substantial amount of money into a charitable remainder trust, take the tax deduction, but still control the use and distributions of those monies or assets. Very, very powerful tool for a larger estate. The next trust to talk about quickly, Qualified Personal Residence Trust, QPRT. The purpose of this is essentially to take a house that may have a significant capital gains basis issue. There may be a lot of profit on the sale. And what you're allowed to do is transfer to a trust for a period of a certain amount of time. And at the end of that, it then goes to the beneficiaries with a lower value, a lower basis than it would have been had they received it through an inheritance or a gift. It's good and bad. It's not very common because it's complex, and you're betting on the number of years that you're going to use it as residence. You may expect to live for 20 years, and you put it into a trust for 20 years, and you live more, and now your children own your house. Also, the people who receive the house, the beneficiaries of the trust, they may have creditor issues, and at the time they receive it, beneficiaries or the creditors of the beneficiaries can now attach those interests. So it's not really the most popular or common trust used. I've maybe had like one person in the course of my history who actually wanted it. But it is good. It's good, again, like I said, for people that have a house that has appreciated significantly. There are many, many people I come across that have lived in their same house for 40, 50 years. They bought it for like $4,000 and now it's worth like $700. So it is an interesting vehicle. If there's somebody in that circumstance wants to talk to me about it, contact me separately. I don't want to spend a lot of time. The next one is a very common one. It's a qualified terminal interest property called a Q-tip. Often used for blended families or families that have a second marriage. So you may have children from a previous marriage. It allows many things. You can shift marital assets if you are past the $5 or $10 million range. You can shift some of the higher assets to a spouse to delay certain tax consequences. Could be capital gains tax consequences you want to avoid. The purpose of the trust is to provide a lifetime stream of income to the ex-spouse, but not the assets themselves. The assets themselves will pass to the children that are named. Now, they could be the children of a prior relationship, or they could be the children of the current one. It allows you to provide income for the spouse and preserve assets for the children. And it can be even in the same family. Sometimes the interest that you're looking to protect is just against your spouse from spending too much money after you pass. You want to ensure that there's money left for your children. You may be concerned that your spouse may remarry. And that person will now have access to the assets you leave if they pass directly. They may also take assets in a divorce that later could have been assets for your children. So a Q-tip trust is a very, very powerful vehicle for providing for an entire family, a lineage, providing for your spouse as well as your children from that and a current relationship, and protecting against creditors and divorce in the future. It really allows you to ensure that your money lasts and really takes care of your family. And the last point here, just real quick, I'll give you a second because I think I quickly talked about what appears on most of these slides. Say from your spouse's creditors, the income. Oh, here, the income to your spouse is not protected. So let's say you transfer a substantial asset, and because you're concerned of your spouse's spending or future marriage or whatever. If they're receiving substantial income, that income goes to them directly. It's outside of the trust protection, and that would be subject to creditor attachment. So something, if that's the purpose of your planning, it's one thing that you need to consider is how much income is going to be distributed. Talk a little bit about, I'm just going to pass that. Let me talk real quick, the fraudulent transfer claims. This is an important topic really for all trust transfers as well as gifting, as I mentioned, the 3 years, and Medicaid that we'll talk about in a second. If you transfer assets to avoid creditors within a 5-year window, most either creditors or governmental organizations or entities are able to allege it was a fraudulent conveyance and seek to undo the transfer. So any assets that you're looking to transfer into the trust that we've been discussing, any assets that you might be gifting that we discussed, you need to consider and speak with an attorney about the fraudulent conveyance issues. So moving on now to Medicaid trusts, not to be confused with special needs trusts, which we'll talk about in a second. A Medicaid trust is specifically to help a person qualify for Medicaid. A very unique form of trust because unlike most trusts, unlike the special needs that we'll talk about, the grantor can also be the beneficiary. And then that person's children or spouse could be what's called the residual beneficiaries, meaning once that person has exhausted their need or passed, children or spouse receive it. And you can shelter enough assets to qualify for Medicaid. Usually there's going to be special limits that are set. Medicaid will set how much income you can receive, so you can set up the trust to disperse just enough income so that you don't tip the scale and lose the potential Medicaid qualification. It gives you the same protection that I told you from the irrevocable trusts, like creditor protection, estate protection, because again, your trust is the one who owns the property. But in this kind, just like the revocable, the first one we talked about, it allows you to control your assets. But with one restriction, you cannot use it for other healthcare purposes. I don't know what the reason is for that. I think it's just because they don't want you to be paying one company and then another, or paying for private care when the government is flipping the bill for the rest of your care. This trust, as I said before, also has the 5-year look back. The income is limited to Medicaid, like I mentioned. The difficult part here in the last part on that slide is it's hard to tell what's going to happen with somebody's long-term care. So if you're planning a trust for the sole purpose of that issue, you really need to look farther down the line in ways that you may not be familiar. You might want to talk to family physicians. You might want to look at your family lineage and see what's been the kind of the history and the lifestyle and length of your family when making these decisions. The last type of trust we're going to talk about, which is becoming more and more popular, is a special needs trust. The purpose of a special needs trust is to protect a person who is or will be receiving governmental benefits from jeopardizing those benefits by having assets or income that exceed the limits for either like Social Security income, SSI, or food stamps, other kind of governmental benefits. You must be you must be under 65 years of age to be able to use a special needs trust. And then there's mentioned up here a self-settled special needs trust, which means you're setting up the trust for yourself, or the person who's setting up the trust is setting up for him or herself. Very common instance will be an individual gets in a car accident and is a recipient of governmental benefits. Car accident settlement is going to be a sizable asset to them. That person would want to put it into a special needs trust, but because they're doing it for themselves, the government wants to make sure that it's a proper structure. Additionally, you'll have to notify the Attorney General's office of the application so that Medicaid will later have a lien for it. But the important part to take from this is just if you're going to be setting up for yourself, or you know somebody who is setting one up for themselves because you're about to receive money, then you need to go before a court for approval. Another part about special needs trust, I'm just trying to figure out if it's in the rest of my slides or if I should cover it now. You need to contemplate the people in your plan and their future, meaning you need to look at whomever is going to be your designated beneficiaries in your will or your trust and see whether or not you think there's going to be issues where in their future they may need a special needs trust. I have a client right now, his wife has dementia, his children have special needs, and he's taking care of all of them. He needs significant special needs trust because they all are either receiving benefits or will likely when they grow older and move on to their own to the extent they will. So you need to look at what's going to happen to your beneficiaries too, not just what is currently happening, because special needs can develop later in their lives. So you want to put it in, and sometimes I even recommend a catch-all special needs trust provision that says if any of my beneficiaries are receiving or are likely to be receiving governmental benefits in the future, the executor has the option and the discretion to create a special needs trust for him or her. It's catch-all. It will often protect people well, and it's just a very important issue for all estate planning. I know I'm close to my time. Like I said in the beginning, I will stay afterwards for any questions. Let's talk about some other estate planning devices other than the wills and trusts. The first is the most common, is a power of attorney, and that is giving somebody the power to act as your attorney. They can make financial decisions, business, and other decisions. There are three kinds. There's a springing, durable, and a limited. A springing is one that comes into effect, that has language that says it comes into effect at a person's disability or incapacitation. It springs into effect under those circumstances. A durable is effective when it is signed and it lasts forever until it's revoked. So it's durable, lasts forever. And then a limited is given to people for a specific purpose. A common one is you'll give your attorney one to do a real estate closing because you don't want to be present at the closing. All of them are effective when they are signed, but they can only be used by the person you're granting it to when it's delivered to them. So I often tell my clients, if you're going to do a durable, but you have maybe trust issues, you may want to hold on to it and tell that person where it can be located if it becomes necessary. If you become hospitalized or you are out of the country and you can't get your mortgage paid, the person has access to it, but they can't take it and start using it when you don't want them to and transfer your assets. Now, the reason why you might want to do a durable over springing, even when you have trust issues, is the springing adds that added layer of having to prove an incapacitation. You might be hospitalized and not vocal, but you can blink. So then the question is, are you disabled or not? And if you're in a circumstance like this and a loved one is using a power of attorney, you don't want them to have to go to court and prove whether or not you're incapacitated. You want their roles to be easy as possible to give you the most help with the least inconvenience to them. Next is a healthcare directive, power of attorney. I call them separately because I really do them as two different documents. The healthcare directive, well, the power of attorney will describe what you want a person to do in certain medical situations. So my common healthcare directive will ask things like, do you want experimental surgery? Do you want painkillers? Do you want life support? So that the decisions that you would want to be made for you will be consistent with what your wishes are. You don't want to leave somebody having to make these decisions for you because, first of all, they're very, very challenging decisions to make, and they may not make the ones that you want. People may not be as clear on what you would prefer. And the second part that I do as a separate document is the power of attorney, which is where you actually name an individual to be the one who makes these decisions. Even though you're spelling out some of them in your healthcare directive, there's going to be many that aren't spelled out. So you want to not only name somebody who will serve in that capacity, but as I said in the beginning, you want to name some alternatives in case that person can't or is unwilling to serve in that role, make those decisions for you. Another common part to estate planning will be final dispositions or instructions. Do you want to be cremated or buried? Where? You may have family plots that you want to identify. If you want your ashes distributed, anything that's important to you, it's not usually going to be addressed in a will or a trust instrument. So you want to do this final disposition. It can be done formally or informally. Just attach it to your papers, put it in the same box. It's not any requirements or something I usually recommend. Real quick, some things to consider. As I talked about, guardianship designation is very important. If you have children, you want to designate where they should go. Not only who takes care of them, but who takes care of their money. That can be different issues. You may have your parents that are savvy with investing that you want to handle their money, but they may not be young enough to handle young children. You may want to separate that. You may want to have the same person handling it because they're raising them. So it's something you should consider. And as I said before, have some backups. It's very important in case people can't. One thing about it, it's not a binding designation. I do a lot of family divorce work, and a lot of people, once they divorce, don't want the other parent to have custody of their children if they pass. So they'll put in their will that they want somebody else other than the parent. That's not binding. It's persuasive on the court because the parent of primary residence, the parent who has the child most of the time, is the one that the court will look to when determining what might be in the child's best interest. But the other parent has a constitutional right to a relationship with his or her child and has the paramount right to seek custody of that. So while it doesn't bind the court, I always urge clients to include a provision if they feel that way about their ex-spouse because it is persuasive and it also will identify to the other person whom it is that you think should be doing that so they know that that was your wish also. let's take a minute to talk about non-probate assets. As I told you before, probate assets are the ones that go through your will. Non-probate assets do not go through your will. They go directly to a named beneficiary. First type is life insurance. And that's, I'm not going to belabor all these points. I think we covered most of them. You know, the policy is paid immediately so that your beneficiary has the ability to pay bills quickly, handle estate assets. The thing about probate assets, or I'm sorry, about non-probate assets that's important to take from here, they're non-probate assets, so as I said, they do not pass through your estate, but they are counted towards the total value of the estate for estate and inheritance tax purposes. So while you may be crafty in providing that all of your assets are going to pass outside of non-probate, I'm sorry, not trust assets, just co-properties, gifted properties, things like that, that are part of the 3-year look back. But the non-probate assets like life insurance, retirement accounts that go to named beneficiaries, joint bank accounts, they will be counted for tax purposes, but they do not pass. So life insurance is one, as I said just a second ago. POD accounts or joint accounts are another's. Any property that is co-owned, as I said much earlier. So you have jointly held real estate, POD accounts, jointly held investment or bank accounts, and retirement accounts, all have somebody named who is to receive it. So that takes it out of the probate process. So they are non-probate assets, but they are all considered for tax purposes. Now, I know I went a moment or two over my time. Actually, most of the time I usually try to keep this under 50 minutes. But real quick, I'm going to ask you for some poll questions just to get a sense of where everybody's coming from. You can just take a second and fill out the questions here. This way I know where people came from, what works and what doesn't work, so we can better serve you in the future. I'm not going to be posting these results either, so I mean that probably doesn't matter much to people, but just so that you know. All right, so, well, that's good to know. At least my word of mouth is effective. Is this a good time for the webinars? All right, good to know that we got the right times. A couple more, and we'll move on to questions. Oh, interesting balance, okay. I believe we have 2 more. Bear with me. This one's probably the most important of the evening, at least for me, so I can make sure that I'm doing my job. And survey says, yes, I did. Great. Last one. This is just so I know if you need more help. Like I said, nobody finds out who you are or if you are interested in whether or not you are. But if there's more help I can give, I certainly will. Oh, interesting break there too. All right, and I believe there's a way to indicate that you might get a post survey that allows you to indicate if you did want to speak. If not, I'm sure you all have my emails because you got email confirmations. You can also email me either your questions or to set up a time for us to discuss these issues. All right, so now if anybody has questions, let me open up, see if anybody posted while I was talking. Here's also our contact information. For some reason you don't have it, my email, my phone number, our address. It's an old picture, so half of our staff isn't here, but let me see if we got any questions. So far, I'm not seeing any questions. I'm going to hang out for another minute or two because I want to make sure not to miss anything. You might have been busy listening and not making a note, so I don't want to shortchange yours. So it'll take as much time as needed. Still not seeing any. I'm going on the assumption that you could hear me the whole time because nobody posted any comments that they couldn't, and my microphone is recording. So I'm going to give it another second. And all right, then I'm going to wish you all a good night. Thank you for coming. Hope you have a Merry Christmas, a Happy New Year. We do these webinars usually it's the last Thursday of every month at 6:30. We didn't do it this time, because of the New Year holiday, and so sometimes holidays or scheduling doesn't allow. My website will always have the dates as well as the upcoming webinars for the next few months. That's micklinlawgroup.com. This will also be posted within a few days on that website and my YouTube page. So with that, I wish you a good night. I hope to sort of see you at least electronically next month. Have a good holiday.